So, Fourth Amendment, we're going to talk about search and seizure, which takes away my first question, what is the Fourth Amendment? So I'll give that one to you. So let's talk about, well, we talked about this in the introduction chapters, first couple of chapters. When we talk about it protects us from search and seizure. I mean, that's kind of how colloquially people will say it. It's a protection from search and seizure. But it's not a global, universal 100% protection from search and seizure. Because can I be searched if I'm,
As long as it's lawful.
as long as it's lawful? We're going to use a word, it is lawful, we're going to use a word that's in the Constitution, reasonable. Right. It protects persons from unreasonable searches and seizures. We're going to talk about what is the definition of reason. So there's two different prongs we're going to talk about on the Fourth Amendment. First of all, we are going to talk about the fact that it protects people, their homes, their papers, their articles from unreasonable searches and seizures, but also that no warrant shall be issued
Without probable cause.
without probable cause. So those are the two halves. So even though we're all in the same amendment, we hear about this, the Fourth Amendment, search and seizure. We really have two separate clauses in that Fourth Amendment. And there's two schools of thought. Some people say that those are intertwined. Oh, sure, they're two different sentences, but they're really, the part about the warrants is going to talk about, well, warrant can only be issued with probable cause, which means that you can only be searched with a search warrant if it's reasonable. Others will say, the other school of thought is that those are just two independent clauses. The first half of the Fourth Amendment says you can't be searched unreasonably. Period. We're done with that. And the second half says, and also, if a warrant is going to be issued, it has to be issued based on probable cause. So we're going to, if you look at chapter 212, that's going to give you the two names of those two schools of thought. The conventional school of thought says that those two are intertwined. The reasonableness school of thought says those are two different clauses. The reasonableness approach versus the conventional approach. But let's talk about who's doing the searching. As I started to say, when we talk about any of the constitutional protections, especially the Bill of Rights, the first 10, who are we protected from?
From the government.
From the government. If there's one thing that I can't stress enough, it's going to be that, and you're going to hear it over and over. Our constitutional protections are from the government, not from each other. We said that with the First Amendment. We talked about, yeah, you could say, we have the freedom of speech. In theory, you could say whatever you want. But if you go up into a bar and start talking all kinds of mess to somebody, and they punch you in the face, did they violate your constitutional rights? Because they stopped you from talking mess? No. Or you could go up to your boss and call your boss out of their name, and they fire you. Did they violate your First Amendment rights? Because you're allowed, you got freedom of speech, you can say whatever you want, right? Oh, they didn't violate your constitutional rights because there are consequences to your speech. Now, the government cannot stop you from saying all kinds of mess, or cannot, in theory, stop you from calling the government out of their name. Now, same thing with the Fourth Amendment. The government cannot search you unreasonably.
And I noticed it goes for all public employees of the government. So, but it has to be if they're acting in that.
Right.
Okay.
So we'll talk about that in just a second. So this has been in the news recently. In fact, there was a computer repairman, computer technician, who worked on Hunter Biden's computer. And it's been in the news in the last day or two because he's coming out saying he's had a lot of challenges, a lot of personal challenges because of this. You ever remember the story where Hunter Biden's computer was taken to the computer repair shop, and then during the repair of his computer, there's a lot of incriminating information found on Hunter Biden's the president's son, by the way. President Biden's son is Hunter Biden. So on this computer that Hunter took to have repaired, a lot of incriminating information, emails that may have documented unlawful activities. Some say that there's documentation on this computer of the president engaging in wrongdoing. Like pay for play, quid pro quo type of stuff where, he's getting paid to allow access for foreign governments to the government, things like that. So a lot of bad stuff. And then there are some pictures of, I believe the pictures of drug use and things like that. So it's just a lot of bad stuff on this computer. And so as the computer technician is going through the computer, fixing it, he finds this stuff. Tells folks about it. Did Hunter Biden have protection from that unreasonable search and seizure? Or was that search unreasonable?
No.
Why not?
Because he voluntarily took that computer.
So he takes away some of the reasonableness by volunteering to take it. Okay, I'll buy that.
And
And
also
then
the
he wasn't
computer
like a
technician.
government official, so it wasn't like they had to have permission to go into it, and you were given him permission because you were paying.
Who's the he? Who's the he you're
You were
talking about?
given
The
the technician.
The technician, right? Okay, I just want to make sure we're not talking about Hunter.
Paying him to do a service.
Right, I don't believe Hunter was a government employee, but I just wanted to clarify. You're talking about the technician. He wasn't a government employee. So just like
Right.
I
but
said, you can't.
At that point, they don't really care who you are, they're just fixing your computer. So whatever they run into, that's what it is, like whatever you left on there, that's what it is. So it's pretty much open at that point for public eye.
There you go.
Idiot for taking it there.
Well, and there are story after story of people getting arrested for child pornography.
I
Well,
mean,
that's
but
the same
if
thing.
your dad's the president, why wouldn't you let him have his people take it and do stuff like that, especially if you've got his information up there? That would make,
There's been some stuff on there
but your dad's the
that shouldn't have
president.
been, that
That's what,
would
that's
have
what,
incriminated Biden at that point.
Mhm.
Yeah, but then.
So explain to me, you touched on it, but I want to hear it again.
There would have been different consequences because those are government employees. So
If you
they
take it
don't
to a
leak
government
that
shop?
information, that could be, that they could easily say that was tyranny or something if they leaked that information.
So tell me again why that computer technician was not or why him searching that computer was not a violation of the Fourth Amendment. Why didn't he violate Hunter Biden's rights? Tell me again. You touched on it.
because he's not a government employee.
There we go. Because this computer technician was not a government employee and we are only protected from the government in these rights. There are other laws that protect us from other people. Don't get me wrong. That computer technician can be in the wrong, but not for the Fourth Amendment.
Mhm.
If he took that computer and sold it, and now that Hunter Biden's out of a computer, could Hunter Biden sue that computer technician?
I mean, he can still slander, he can still sue him for slander or libel, but he would have to prove it.
And you have to prove it, and it would not be a Fourth Amendment violation.
Right.
There are other violations that private parties can be party to, but not this. That's what I'm getting at. Yes.
So that gives the government reasonableness to search the rest of Biden. Once the technician put that out there, that gave the government reasonable suspicion enough to go and probable cause to go into Biden's personal stuff, search and seizure.
It would not be out of the realm of possibility. I don't know how the investigation unfolded after that. I don't believe there's any
In
criminal
general.
investigation thereafter.
In general.
But in general, it
That
could
would
be
give
used.
them reason to do so.
And you can use information from outside sources to develop your probable cause. And we're going to talk about the definition of probable cause in a second and how we develop that, where we get that information.
Okay.
So the computer technician, and it's been said, I started to touch on this, it's been said, or it's been done on many occasions where computer technicians have found wrongdoing on computers and turn it over to the police. And that the police have used that information to prosecute. Child pornography is probably one of the most common forms of that. And that's actually where the case law came from. If you look at the Tapley case, US v. Tapley in 2016, that was a child pornography case where a computer technician found information, turned it over to the police, and that person was prosecuted. It was challenged as a Fourth Amendment rights violation, but the court upheld that the computer technician is not the government.
Right.
So just like you ladies said, there is no Fourth Amendment violation because they are not acting as government officials. So what is reasonable? That's what we have to determine. That's a very broad term with the Constitution, and a lot of our amendments, our Bill of Rights are going to use broad terms. We talked about the Second Amendment, we talked about the Fourth Amendment, we talked about having these just general terms that have to be fleshed out a lot of times through case law. So one of the biggest terms that you need to remember for for probable cause, or what is reasonable, is totality of the circumstances. Totality of the circumstances. You can't just take one narrow approach. The entire picture has to be painted before you can understand if this search was reasonable. For instance, if we give a scenario of a car that is pulled over and the officer searches the car and finds drugs. I'm purposely giving very little information. The officer searches the car and finds drugs. Do we know if that's a reasonable search?
No. We don't know that, but the officer would have to justify that search.
Right. So paint me a picture. Make that search reasonable.
Outlet light in the back, a broken light.
Okay, see, now you have a reason to pull them over. Okay. Do you have a reason to search that car?
Consent.
Consent. Is it reasonable to search a car if you ask the solo occupant of that car? If you ask the solo occupant of that car for permission to search it, if the officer asks for permission to search that car and the solo occupant says, sure, you can search this car, is it reasonable for the officer to search?
Yes.
Absolutely.
How about if the car
That is reasonable.
swerving on the road? Now he don't need consent. If the car was swerving on the road, like as a drunken driver or something like that, he could justify why he searched the car.
So very few traffic stops are going to be based on consent. Usually, it's very difficult to have a consensual traffic stop. You would have, to paint that picture, I would have to imagine pulling alongside and saying, hey, do you mind pulling over? Things like that. That's probably not going to happen very often. You could probably do that with a parked car. Come behind a car, have an officer come behind a car that's already parked, walk into the car, hey, do you mind if I chat with you for a second? That would be a consensual encounter, but we still don't have a consensual search yet. But the actual traffic violation is probably, or the traffic stop is going to have to be based on some sort of reasonable suspicion to detain. We need some reason to have that vehicle stopped lawfully before we can initiate some sort of reasonable search. Yes, ma'am.
Yeah, but if that car is pulled over and it's like a traffic zone and nobody's in it, and there's not like anything to represent that it's, somebody's coming back for it,
Right.
In the process of getting it towed or something, they might go to the car, to see if it's got ID or something, I don't know.
Are they justified to do that?
We have to determine if it's reasonable. So,
Well, it's in a traffic area, so they would be able to move it. I know.
They can move it, they can tow it, but
If
are
there's
they
no parking
justified
zone?
to search it? No, I don't believe so.
Well, if you looked in the window and saw something, then he could.
Plain
Now
view,
we're-
in plain view.
now we're a couple different things.
Yeah.
So you touched on something that I wanted to get on. So you said if you look through a window. So let's talk about how you develop this probable cause. How do representatives of the government, and in this case, the most common representative of the government is going to be law enforcement, usually. However, it is not relegated to just law enforcement. As Ms. Scott said, any representative of the government falls under the purview of the Fourth Amendment protection. So the public has the right to be free from unreasonable searches and seizures from the government, although it doesn't say that in word for word. And usually the government is going to be law enforcement, deputies, officers, and then federal agents, FBI, ATF, things like that. But there are other representatives of the government that you both talked about. Did you guys see what those were? The IRS is one of them.
Yeah.
They can go through your records. It may not necessarily be an enforcement arm. There are situations wherein the post office can go through your mail. Yeah, but postal inspectors in general are law enforcement. But any branch of the government who would have some sort of regulatory capacity could have cause to need to look into. Searches could be searches of your records, searches of your home, searches of your person, your car, but don't forget the records. Because I don't have to take anything from you to search your bank account information, do I? I'm not taking your money from you.
Mhm.
I just want information. But you still have the right to be free from unreasonable searches of that information. I mean, there's a ton of times where I wanted information when I was conducting investigations into somebody's whereabouts. And I wanted to know either A, where they are right now, or where they were previously. How could I do that? How could I, in today's technology age, how can I find out where you are right now? Cell phone records. So case law has said recently, only in the last few years, case law has said that I can get a warrant. A law enforcement officer can get a warrant and find out where you are currently with probable cause. But it has to be with a warrant. Although that is information, I'm not taking anything from you. The courts have ruled that you should be free from unreasonably having that information obtained. So that's why law enforcement investigators have to get a warrant before they can pull these cell phone rings. But with enough probable cause and proving to a magistrate or a judge the rationality, then a warrant can be signed. That warrant is given to a cell phone company, and a cell phone company will start giving pings. And every few minutes, my phone would go off, and we could literally follow somebody and find out exactly, well, within reason, approximately where they were. So with that, you're not, what are you losing? What are you being free from being searched? And if I'm not taking anything, nothing's being seized. I'm not going to your home, I'm not going to your pockets, I'm not going into your car.
For privacy.
Your privacy, exactly. Your privacy. So how do we develop this probable cause? That if the Fourth Amendment says that warrants can only be issued upon probable cause. And we define probable cause as, you know, enough information to show that the crime probably, there's a fair probability that a crime is occurring or a crime has occurred. Where do I get that info? We'll talk about the traffic stop. Alexis, I think you said, yeah, in your scenario, the officer looked through the window and saw it in plain view, the narcotics in plain view. Is that what you said?
Mhm.
So if the officer saw drugs in a car, do you think that officer has enough probable cause to believe there's drugs in the car?
Drugs, paraphernalia, anything of that nature.
Mhm.
We'll make it easy. If there's a Scarface-sized pile of cocaine in the backseat, is that probable cause to believe there's cocaine in that car?
Yeah.
Is there a fair probability to believe there's cocaine in that car?
Yeah.
Yeah, because the officer saw it. And we can talk about the plain view doctrine and whatnot. And we're talking about how we search, how officers get into and search different locations. But by their own observations, officers can develop probable cause.
Because it's less than evidence. You don't have to have actual evidence. You just have to be able to justify it.
Right. So what would be, in that case, it is evidence, right? A big old pile of cocaine is evidence. But Ms. Edgerton said something that was less than evidence, perhaps. You said paraphernalia. So if
So
there
what if it
was,
was just like a razor and like a plate or something and it had residue.
so I walked up, I'll give you an example. I walked up on a car one time. Just the example I showed, there was a car parked and we were walking through the neighborhood and just walked up on the car. And I look in the car and there's a guy with a children's book on his lap in the passenger seat. I remember it was a hardback children's book. And he had a razor in one hand and a whole mess of crack cocaine that he was cutting up into cubes. But if I hadn't seen the actual crack cocaine that was being cut up, if I had just seen
The children.
what she said, just saw the children's book with residue and a razor sitting on that. Do you think, in my experience, that it would make me come to some sort of opinion?
Yeah, that would probably cause a stay on the
Yeah.
car, see who comes to the car.
If I pulled that car over, if an officer pulled that car over and saw a razor with white residue on a children's book, is white residue illegal? In general, is all white residue
No.
illegal?
No, but that's.
So we don't have a verified crime, right? We just have a hard surface with a razor blade and white residue.
Right.
But do you think that there's a fair probability if an officer has seen that before and knows that in the past, hard surfaces have been used to cut cocaine base into cubes, and now there's a razor blade with white residue on a hard surface?
Yeah, that gets.
Regardless of the
Law
children, right?
enforcement, the law enforcement, so they've seen it before and that given justification.
So then perhaps that develops enough probable cause for that search, that subsequent search to be reasonable, right? But what if that officer searches and come to find out that is flour and this gentleman sells razor blades for a living? He's a traveling razor blade salesman, and on his off-duty time, he sells children's books.
Then you got.
And
I mean, you
his
still have
wife wanted to
proper
get him, told him to go get some flour on the way home from his book sales job. He did, and it broke a little bit, and a little bit of residue, white flour residue on that book. Do we have a crime there? Is that a crime?
No,
No. So flour on his children's books, and he sells razor blades, is not a crime.
No.
Did the officer violate his rights when they searched that car because they were wrong?
no,
No.
you got the exclusionary rule.
There is the exclusionary rule, but it would, we'll talk about that. But just the fact that the officer was wrong
Yeah, that's right.
does not make that search unreasonable.
Right.
Okay.
Because we didn't
What
know
determines
the time.
reasonability is the previous articulable facts,
Right.
Mhm.
which is another term you're gonna see in your book, articulable facts. The officer painted a picture that made them have the justification, justified their reasonable belief.
Right.
And regardless of the fact of whether or not they were right or not, the search was still reasonable.
Mhm.
The officer doesn't have to be right. Being wrong doesn't take away the reasonableness. Where else can an officer or investigator get information that would give them reasonable or a probable cause?
Witness.
Give me an example. You said a witness.
So say you were around your friends and you decided to say something just because it crossed your mind and it sounded like you were prepared to do it.
So we can have neighbors who say, hey, my neighbor is involved in criminal activity. We can stick with narcotics. My neighbor grows marijuana in their house. I see it. I see him bring it in. I see him bring it out. I know what's going on. And they give all the details. In fact, hey, I can tell you exactly what time. And the officer goes in there and verifies, yeah, that is what time they come and go. With enough neighbors saying that, do you think it's reasonable to take enforcement action?
Yes.
Did the officer ever see them coming and going?
No.
So the officer in a proper investigation or a thorough investigation, officers may want to verify that information vet it a little bit more, and maybe go and make their own observations.
But you said it was a couple.
Most likely that's what they would do, right?
Most likely. But I'm talking about theoretically.
Mhm.
Officers, investigators, law enforcement, the government can develop probable cause based on other people's statements. It is reasonable.
Mhm.
Those are the two ways that probable cause are developed: observationally and informationally. We get information from others, and the government makes their own observations. And again, government being usually law enforcement. Do you think that neighbor who is calling the police saying that their neighbor is selling or is growing marijuana, do you think they're pretty, in general, they're pretty okay with their name being put out there?
Nope.
Usually
And they probably the other sellers in the neighborhood.
that happens. So we probably need a way to protect the person who's reporting that information, the source of the information. Because officers are going to, if we're going to follow the Constitution, they're gonna have to get a warrant, right? They're gonna go search that house. So they're gonna go to a judge, they're gonna write a story to the judge and say, this is the information we have, these are observations. We would like to search this house and we think we're gonna find cannabis. Well, when they write that warrant, that becomes public record. That's gonna go into the case.
Mhm.
And if you write, the neighbor to the right said, John Smith said that he saw 5 different times, 9 o'clock, 11 o'clock, 1 o'clock, and 3 o'clock, and 5 o'clock, that they saw people coming and going, buying dope. Well, that's not gonna do a very good job of protecting John Smith, right? How do we protect John Smith then? Because we can't just tell if the officers never saw it, they have to write down somebody saw it, right? How are we going to protect John Smith?
Leave his name out of it, number one.
Do you think the judge is gonna be super cool with that?
Well, you can't, I'm talking about out of the written
Don't you have
document,
the
maybe.
informant number?
Wording
That
of
where the name
The
is
wording
happened to be or
is-
something?
put a concerned neighbor.
So, couple options. One, you can take that information and then conduct a separate investigation, right? If the officers develop their own probable cause based on their observations, sure, but there's still gonna be some questions as to where did this information come? You didn't just start watching the house randomly.
Mhm.
So there's a case, the Hobbs case, HOBBS. The Hobbs case says that you can seal portions of a search warrant from the public, including the defendant, which may seem like a violation of the defendant's rights, which is why we needed to have a case law developed on it. That portion of the search warrant can be sealed from public view to include the defendant if it is to preserve the identity of a confidential informant.
I've seen a lot, I think, I like Judge Judy, that's Judge Judy, so I've seen a lot of blackout stuff. It don't.
We also
only have to
redact
be-
stuff, yeah, for
Yeah,
privacy, especially on TV, but Hobbs specifically will protect the identity of an informant, a
Mhm.
confidential informant. And that portion of the search warrant is sealed. So let's talk about the service of that search warrant. So we said we have to go to a judge. The portions of that search warrant are going to be, first of all, there's going to be a different level of experience and a different level of knowledge from an experienced investigator and the layperson. So why is it important? What do you think an officer would know if they were watching a house and they saw people coming and going and exchanging money through the window and leaving every few minutes? The layperson may think maybe they're selling ice cream. Maybe this is a Girl Scout cookie headquarters. What is the officer going to think? What do you think they're selling? What is the officer going to think they're selling? Drugs. Why? Why? In that quick little story, why does the officer and probably you?
You would pass something through the window.
Is it reasonable to sell things through the window of a house every few minutes? Is that normal? No.
Even the lady in the neighborhood, they used to sell the Kool-Aid, but you didn't have to go in her house.
So the officer is going to have to, one, articulate what they saw, but two, explain why what they saw is applicable to things they've seen in the past. It's not just here and now. It's going to be the totality of the circumstances. In the past, I've read cases where they were selling dope through windows. In the past, I've arrested 20 people who were selling dope through windows, things like that. So the officer's training and experience in the search warrant is going to be crucial, and that's going to be a portion of that search warrant. Then there's going to be a portion of the search warrant that talks about the story, the narrative, the probable cause. You're going to literally just tell the story of what happened. There's a portion of that search warrant that's going to talk about the house. Is it going to be sealed or not? Because in the end, who gets to decide whether or not this is sealed?
Yeah.
The judge, yeah. It's not the officer, it's not the investigator. In the end, the judge has complete control whether they sign any portion of this. The judge can determine, okay, you told me a great story, but I don't see it. Or the judge can say, I think a more experienced investigator might be able to articulate this, but you haven't told me where your training experience helped you tell this story. Or they may say, okay, I see what you're saying about this. You want to seal this case, but why? You didn't even tell me why. Why is this going to be Hobbs? what about the information? Why does it need to be protected? The courts have also determined that there are certain times when search warrants can be served. In general, search warrants should be served during the day. But there's exception. There is night service exception in a search warrant. Let's talk about that. Why do you think there needs to be permission to serve a search warrant at night?
Some people work first shift.
So some people are sleeping during the day, or
No, some people are working during the day.
right?
Some of those activities
Happen.
are happening at nighttime.
So that would be our justification to violate that rule. But why is there a rule that says that search warrants should be generally served during the day?
Because you gotta check somebody. If you're gonna do it today.
It all goes to reasonableness.
Right.
We don't want the government kicking our doors down in the middle of the night. In general, there should be an additional layer of reasonableness for us to have a search warrant served at night, because our families are home at night. People have an additional expectation of privacy at night. If we're sleeping in our bed, we don't expect to be woken up. However, just like many other rules, there's exceptions. And Mr. Thornton described one of those. If the activity only occurs at night, why would you serve a search warrant during the day? You're not going to find that activity. Many times, the investigations that I've shared with you, some of the underground casinos that we would infiltrate and ultimately serve a search warrant on, a lot of that activity would only occur at night. So we would ask the judge, hey, do you mind if we serve this at night instead of during the day? But instead of just, in addition to just asking, what else do you think we told him or her?
The reason.
The reason. And what are the reasons? Why do I want to serve the search warrant at night?
There's nobody there during the day. Like,
Exactly. There's nobody there. I don't want to serve a search warrant and not have any results. So we ask for night service. We ask for Hobbs if there's a confidential informant. The Breonna Taylor case. So part of that case, the Breonna Taylor case, was part of the controversy of that case was there was an allegation that the officers kicked in the door, made entry, surprised the occupants, and the occupants defended themselves by shooting at the officers. I don't remember if any officers did. Is that unlawful? Well, first of all, when we serve a search warrant, are officers allowed to, I say kick open the door, battering ram, kick it, shoulder it, force open a locked door? In a search warrant, does that give those serving the search warrant authorization to force open that door by any of those means? Battering ram, kicking,
But there's a no-knock order.
yes.
But aren't you even?
If you have a search warrant for this door, for this house, are we allowed to kick open this door?
No, you have to have warrant must be
But aren't you supposed
specific.
to announce yourself to everybody?
So it's saying announce ourselves. If we have,
Warrant has to be specific for no
Specific.
knock.
and I think I heard exigent circumstances over here. So, in general, who are we serving search warrants on? Who are search warrants being served on? Criminals, okay? In general, do you think that criminals are going to invite you in and offer you a cup of tea?
No.
Usually not. That makes search warrants a lot more enjoyable for sure. If I got a cup of tea every time I served a search warrant. But usually folks aren't going to come to the door and invite you in. So there is going to have to be some sort of forced entry. So yes, a search warrant, that is what a search warrant gives. The search warrant gives the investigators, those serving the search warrant, the authorization to enter that property by any means necessary. In general. Any reasonable means. And those reasonable means would be forcing that door open. Or if you want to check it, You don't have to, an experienced service is going to check that door, see if it's locked first, because you're gonna save yourself a lot of time. However, just because there is authorization to make forced entry or any entry without, so essentially the search warrant has taken that door away. Has legally made that door disappear. You can come through the threshold, however, you can open it or you can kick it. But we talked about knock and notice. Knock and announce. I think your book calls it knock and announce. You'll hear me say knock and notice sometimes. Especially at night. Give the Breonna Taylor case. In just those facts, regardless of the controversy, and we'll take away even the Breonna name because there's a lot of emotion attached to that case specifically. But in general, is it reasonable for a homeowner sleeping at 1 o'clock in the morning, they hears their door get kicked down and dark figures come through that door? Is it reasonable for that homeowner to defend their home?
Exactly. Mhm.
Yeah.
I don't think there's not gonna be too much. If I heard my door get kicked down in the middle of the night, am I going to assume that it's the police coming in?
No.
No.
How would I know that it is the police?
Have to announce themselves.
Announce themselves. Maybe they're wearing uniforms. They keep saying, please, please, please. They've got insignias. Those are the only ways. I mean, if you're in the middle of the night, there's really a limited number of ways.
Dark.
What's that?
You're not looking for that in the dark.
Exactly.
Mhm.
Especially at night. However, well, especially at night. So that is where knock and notice, knock and announce comes in. To make that more reasonable, there has to be an announcement outside before the service of the search warrant. There has to be some sort of open up, we have a warrant, this is the police. That's an announcement. And a reasonable amount of time for the occupants to answer the door. What do you think is reasonable? How long do you think?
I mean, and
Now,
that
the book
changes.
say 15 to 20 seconds.
What would change that?
Mhm.
If there was a hostage.
If I was going to ask you, in fact, I'll ask it again. I want you to listen to the question. When
What would
serving a
change
search
that?
warrant, give me a second. I'm going to ask the question again. When serving a search warrant, how long is a reasonable amount of time to wait for that door to get open? Now that you've heard that question, when serving a search warrant, what is a reasonable amount of time for the door to be opened? Before you answer, what questions do you want to ask me about that scenario?
What time of day is it?
What time of night?
What time of day is it?
Yes.
Why is that going to make a difference?
At 1 o'clock in the morning, I'm 3 sheets of wind, I'm done, I'm asleep. I'm
What
a
else?
very deep sleeper myself,
So it's going to take you longer.
it's gonna take me longer to get up. Officers can see lights coming on in the house, depending upon where your bedroom is. They can hear feet, they can hear, in my case, they can hear my dog.
What else? What other questions do you want to ask me?
He answered my question.
I mean, where they're at in the house.
Where are they in the house?
I mean,
We may not know that. I mean, I have an answer for you that. What about, did I tell you what crime we're investigating in this? Does that matter?
it should.
Why? Why would it matter what type of crime? Give me some scenarios.
Be armed
You
or
gotta
not.
know if they're gonna be weapons in the house.
Do you think you're gonna give them less or more notice
Less,
Less.
if
Because-
there's weapons.
if there's weapons?
Yeah.
So maybe you're serving a search warrant, maybe the search warrant is for unlawful gun sales and possession. How would it, if it was a narcotics warrant, how would that affect your decision?
We was going quick,
You
we
would-
don't want to flush it.
Oh, we're gonna go in quick because we don't want them to flush it. How can you keep them from flushing it?
Turn the water off.
Turn the water on.
I mean, they still got that good first flush though. So you still gonna be short.
So, time of day, type of warrant, type of activity, number of occupants, things like that. Would it matter to you if, because not all search warrants are on houses, what did I just say that we served a lot of search warrants on?
Cars and all.
To underground casinos. Underground casinos aren't in houses, they're a commercial property. Does that matter? Would that play a role in your decision whether you're gonna knock a notice?
Yeah.
Are there gonna be people sleeping in the casino and things like that?
No.
They do, but.
It's gonna be
Not no-
for other reasons. But it's gonna play, but we also talked about exigency. So we need to, all these factors that you asked me about, those are gonna go into the judge in factoring that decision or forming that decision as to whether or not that judge is going to approve a no-knock warrant. Because a no-knock warrant is going to be more of a violation of rights. And when I say violation of rights, it doesn't mean unlawful violation, right, or unreasonable. It just means that, because that's what a search warrant is. A search warrant is violating your right to privacy. You have a right to be free from unlawful searches and seizures, or excuse me, from unreasonable searches and seizures. A search warrant is going to lawfully violate that right. So just because I use the term violate the right, I'm talking about violate protection. Lawfully. So an additional protection is the fact that folks are free from these no-knock warrants. However, they are lawful if they're justified. Let's talk about how folks end up getting searched. But before we do, so I heard somebody, I think it was Ms. Scott, talk about the exclusionary rule. What does that mean to you?
Evidence being allowed, without a warrant or probable cause, is probable cause involved in that?
So if I'm telling you that folks, we all have the right, the Constitution gives us the right to be free from unreasonable searches and seizures in our persons, our property, and our effects. If we have the right to be free from that, and then that right gets violated unlawfully or unreasonably, if I'm selling dope in my house and the officer comes by and says, I got a hunch that he's selling dope in his house, and comes to my house and finds that I have dope. I didn't give him permission. I said, no, you can't come to my house. And he still comes in anyway, no warrant. How, and he finds the dope. Am I guilty of selling dope?
Not guilty, but
no.
he can't use it.
Have I, 100% I've been selling dope.
Okay.
And the officer arrests me and scoops up that dope and we go to court. What should,
You're gonna be released,
It's gonna be
why
thrown
am I
out.
gonna be released?
because you had already told him he couldn't come in, so anything you found out at the point of you telling him he couldn't come in will be excluded.
So there's no lawful reason for this officer to be in the house.
Right.
And despite the fact that they found evidence of a crime, they still arrest. It's gonna be a very difficult case to prove because of the exclusionary rule. Because any evidence that is found in violation of these protections is going to be excluded from the court case. So in the story that I told, the officer had a hunch, came in and found evidence. So without that narcotics, is that going to be a difficult case to prove?
Yep.
And that's why she said that I would be released.
Mhm,
Because the evidence is going to be suppressed.
mhm.
There's going to be a motion to dismiss that evidence based on the fact that it was obtained unlawfully. And then we'll talk about the fruits of the forbidden tree. Yes.
Now, I want to throw something else in on your scenario.
Okay.
Now, there's children in the home. So the officer feel like the children are in danger.
So.
Then if he went in there, he went in there because he felt the children was in danger
Okay.
because of the drugs in the home.
But he was already told no.
Right. Tell me how the children were in danger.
The type of people coming in and out of the home. You got pedophiles, you got drug addicts, you got people with weapons,
But he didn't catch.
How about
them in
this?
the house and got them.
What if I spin your yarn just a little bit
Okay.
differently? What if the officer felt as though the children were in danger because there were chemicals and the chemicals were spilling
Mm-hmm.
and he could see through the window, you've got chemical A and chemical B And through his training experience, he knows that those two chemicals that are spilling out of the tubs are, as the moment they touch, there's going to be an explosion.
Mhm.
Can that officer go inside that house to save those children?
Yes. Now, the exclusionary rule come into effect with that?
Now,
No, that's-
why is that officer going inside the house?
It's just a circumstance.
Yeah.
But what is his goal? What is his one? What is the? When I just told that story, is that officer going in there to investigate a narcotics violation?
No, to save the children.
To save the children.
Mhm.
That is exigent circumstances. It is not, okay, I'm going to go in there, investigate this crime, and oh, by the way, while I'm in there, we're gonna save the children. That's not exigent.
No, I went in there to save the children, and in the interim, this is what I found.
Right. The exclusionary rule says that if any of the rationale to search are violated, then the evidence can be suppressed. It can be excluded from the case. Now, it also says that if evidence that is unlawfully obtained leads to further evidence down the road, that can also be excluded. The exclusionary rule says that the evidence immediately found can be excluded. But if that leads anything that comes from that evidence that is now lawful. So a different yarn. We go into the house, the officer comes in, and I tell, no, don't come in. There's no chemicals. Don't come in. Comes in on his hunch and says, haha, I knew you're selling dope. And then while he's in there, finds a ledger. And in that ledger, he finds all my customers' names and phone numbers. And then he starts contacting them. And 3 of them confess, yeah, I bought dope. And he goes over there and then he asks for consent and goes in their house and finds their dope.
No.
All they can do is get their consent.
No, because the reason why he found it was through the,
Exactly.
unlawful
Every
search.
subsequent piece of that investigation is tainted. It is now we call that the legal term we use. Mr. Thornton, I believe, said it, and so did Ms. Scott, Ms. Edgerton, the fruit of the poisonous tree.
The poison, yeah.
The fruit of the poisonous tree. So anything that comes from that initial violation, no matter how lawful subsequently, it's still a fruit of that initial poisonous tree, and it's still unlawful.
Mhm.
You can do everything right after that, but the very first thing was wrong. It's all.
You find that in cases where criminals are locked up and then they find the officer was dirty, was not good,
Mhm.
doing unlawful things.
In case
A lot of times they let those criminals go.
So let's talk about this. Let's talk about how searches can occur. This is the acronym we're going to use. You've probably seen it if you've taken the other classes from me. You've probably seen it before. The SPICE acronym. S for what?
Search warrant.
Search warrant. We talked about search warrants. We can. Who signs search warrants? Judge or magistrate. Based on
Probable
probable
cause.
cause. Those are 2 things you need to remember. Search warrant is based on anything can be searched with a search warrant probable cause. There are very few limitations because ultimately, if there's a question, the investigator can get a search warrant. Any of the other ones can be trumped by getting a search warrant. However, the P, probable cause. Sometimes probable cause is all we need for the government, or all the government needs to conduct a search. Primarily, that's vehicles. The probable cause exemption or exception to the search warrant. I told you in my story that the officer came in and just on a hunch and searched the home and found dope. Homes have protections. Homes almost always necessitate a search warrant. However, vehicles rarely necessitate a search warrant. Because search warrants, vehicles can leave. So the courts have ruled that officers can search a vehicle if they have enough probable cause. They don't have to leave, go get a search warrant, and come back. Because the vehicle might be gone. If the vehicle is drivable, then the vehicle can be searched based on the same level of probable cause that you would have presented to a judge. So the example we used was there's a big old pile of cocaine in the backseat. And we determined, yeah, is there a fair probability there's cocaine in that car if you see a big pile of cocaine? Yeah. So that vehicle can be searched. But if you saw that big pile of cocaine, that same big pile of cocaine on the dining room table of a house, can the government come in and search? No. Has to be a search warrant. Now, it doesn't mean the government can't secure that home and not let anybody come and go. But they can't go in and search. Incident to arrest. Just a fancy way of saying during or after an arrest. We've determined that if somebody goes to jail, they probably shouldn't take drugs or contraband or guns, weapons into a jail, right? So the government has allowed folks who are being arrested, lawfully arrested, to be searched prior to being taken to jail. So that is an exception. It could be incident to arrest of the person, or what's folks call the lunging distance, or the arm span, the wingspan, things like that. So if the officer, if I'm wanted for a crime, the officer's coming to this classroom, they probably don't need a search warrant coming to a classroom, there's not a lot of expectation of privacy, and I'm wanted for selling dope, or they suspect I'm selling dope. In fact, they watched me through that window as I was selling dope.
Oh, man, you're gonna do.
And then so they come in and they arrest me.
Okay.
So I could have the dope on me, right? If I'm selling dope right here, the dope could be in my pocket, right? Where else could the dope be?
In your office?
If they watch me from that window right there, selling dope right, and students keep coming up to me, where else could the dope be? Could be in the podium. So the law said that you don't need to limit that search. The government isn't limited in their search to just the person. The wingspan. Could I be reaching in here to grab dope? Absolutely. This is my wingspan, my lunging distance. So incident to arrest, the officers can search you. Same thing with a vehicle. What is the wingspan of a vehicle if a driver is being searched? Is the trunk the wingspan?
No.
What does it see? Consent. Huge one. Consent also trumps a lot of things. So in my story where the officer had a hunch that I was selling dope, and the officer comes and knocks on the door and says, hey, I think you're selling dope in the house. Do you mind if I search? And I say, oh, go ahead. And they walk in and find a big old pile of dope. Is that a lawful search?
Yes.
Heck yeah. And you'd be surprised how many people consent. There are just a ton of arrests based on consent. There are just a lot of folks who don't say no. So consent can be person, because there are three primary things that are going to be searched: a person, houses, and vehicles. Those are the three primary categories. So consent applies to all of those. What if you got two roommates and the officer asks for consent to search the living room, and one roommate says, yeah, go ahead, and the other roommate says no? Or two spouses. Who wins? The one that says yes or the one that says no?
No.
Why?
Because
Because it just is. You're right. If one says yes and one says no, one consents and one denies, the denial wins. What if the officer says, I think your roommate is selling dope? I would like to search their room. I was like, I don't know, man. I never go in that room. I got nothing to do with it. We're just roommates. That room is, I never go in it. In fact, the door is locked right now, but go ahead, knock yourself out. You can break the door if you want.
it's not your spot. It's not your space to give that permission for.
Exactly. There's a legal term that we need to write down, and that is standing. I, in that scenario, do not have standing to give consent to search the room that I have never been in and that is locked. This means I don't control it. I don't own it. In the same way that if the officer says, If an officer came up to me after work and said, hey, we want to search Riley's house. Oh, yeah, go ahead. I'm cool with it.
It's right.
Can I give consent
No.
to search Riley's house?
No,
No, I don't have scanning. Same thing. What we leave off, consent? E, exigent circumstances. We touched on that real briefly. Let's talk about that. Exigent or emergency circumstances, both start with E. They both mean it's essentially the same thing. If there is an emergency, the government can come into your house. Now, that emergency has to be legitimate, articulable, reasonable. The idea that you're going in there to save the family from the chemicals because it's getting ready to explode. Or we talk about their children are in danger. If there's a radio call, the officers receive a radio call that says there's children home alone, there's a baby home alone in this home. And the officers go out through the window and they see a baby in a crib and they're knocking on the door and nobody's answering. Could that be an emergency?
yes.
Yeah.
Do they have to see the baby, or could they go because a witness, mentioned it?
Now we're gonna get into a little bit of gray areas about how well you can articulate, and it's gonna go before a judge, and they're gonna make a final determination. So I mean, I wouldn't be comfortable saying absolutely yes or no. But it's just a matter of what is articulable. What can the officers articulate? Is the baby crying? How long has the baby been there? How long did the witnesses say that the parents left 30 seconds ago, right before you got there? Is that as much an emergency as if the witness said the parents left yesterday and the baby's been crying for 24 hours? Now we're building, those are different totalities of the circumstances. But what did we say about exigent circumstances? What are we there to do?
Remove the kids.
Fix the problem. Whatever is causing that emergency, the government is there to fix that problem. The government is not going in there to find cocaine and prosecute. Now, if they go in there and find a big comedic pile of cocaine, do they have to ignore it?
No.
No. But if they want to start looking through drawers, if they went in there to save the baby that's been in there for 24 hours, and they scoop up that baby, and then one partner scoops up the baby, and the other partner goes into the closet and starts looking through the clothes, the pockets of the clothes.
No.
Why is that a no?
That's unlawful.
It's unreasonable, right? That's not why they're there.
The baby was doing in the car.
Right. Unless you're articulating some sort of, we were looking for an itinerary for their tickets. It's going to be unreasonable. Now, if we do find that comedic pile of cocaine, there are steps that can be taken, but even with that pile of cocaine, can the officers start looking through drawers and find other piles of cocaine?
No.
What do they need? Search warrant, yes.
That was,
Still need that search warrant, because the whole point of going in there was not to investigate a crime. It was to solve whatever problem that was. Search warrant, probable cause, incident to arrest, consent, and exigent circumstances. There's two others that may come up in upcoming chapters, PP, parole and probation, and also there are pat downs. Last thing I want to talk about are pat downs. Terry frisk, pat downs, stop and frisk. You've heard all of these terms. Terry v. Ohio is the case law that controls pat downs. Terry v. Ohio is the case that controls pat downs. Terry v. Ohio. Officers are allowed to pat someone down for weapons in their outer clothing. That is not necessarily going into pockets. It's not a cavity search. It is exterior clothing. If they have reasonable suspicion to believe one of two things. if the person is already lawfully stopped, is either armed or dangerous. And that is not armed and dangerous. That is or. And it's also, you'll notice that I said if they are already lawfully stopped. That is not stopping somebody for the purpose of patting them down. You hear that a lot of times. I mean, I've heard it in news broadcasts when people talk about stop and frisk, as if it is combined. I'm going to stop this person and frisk them. And then, no, there has to be a lawful reason for that person to be detained already. Then a pat down can occur. If the officer can articulate why they believe the person is armed or dangerous. Now, that lawful reason to stop could be jaywalking. It could be out past curfew. It could be it could be riding a bike with no headlight. It could be a traffic stop. Any lawful reason. It cannot be, hey, come here, I'm gonna pat you down. There has to be a lawful reason. So if I see somebody walk down the sidewalk, I say, hey, can I chat with you for a second? Would you mind if I search you? Is that a pat down? No, what is that?
Consent.
That is consent.
Oh, I'm sorry.
A stop and frisk has to be a lawful stop with an accompanying frisk.
I'm sorry.
Get groovy. So, armed or dangerous. Last example I want to use. If an officer stopped somebody for jaywalking a year ago, and that person, they stopped them a year ago, Joey Schmuckatelli. They were jaywalking, and while writing a jaywalking ticket, Joey Schmuckatelli just dotted the officer's eye.
Oh, man.
They get into a Donnybrook, and the officer takes him to jail. They do 6 months in jail. Get out of jail, go about their business. They're walking down the block. The officer sees them again. They make eye contact, and the guy, Joey Schmuckatelli, crosses again in the middle of the block, jaywalking. Is that jaywalking illegal? In most jurisdictions, jaywalking is illegal. Does the officer have a lawful right to stop them that second time for the second jaywalking violation?
Yeah.
Is that person a dangerous person? Is the person who punches a police officer in the face, is that a dangerous person?
Yes.
Yeah. So if the officer can articulate that as a dangerous person, they can pat that person down. It is armed or dangerous. In the same way that story had changed, instead of getting a dot in the officer's eye, that the officer had seen a gun in his pocket and arrested him. Do you think a year later, if they stopped him again, that they probably want to pat that guy down? Yeah, that guy carries weapons. He's a dangerous guy. But it doesn't have to be a weapon. He can be armed or dangerous, because dangerous people can also be patted down if the officer can articulate. That's Terry frisk, stop and frisk, pat down, all the same thing. What is the case law that controls that? Terry v. Ohio. Please highlight, write that down, do what you got to do. Last thing, make sure you cover the entire chapter, of course. Last thing I have highlighted that I really wanted you to pay attention to was on page 234, inevitable discovery. Please pay special attention to that. Any questions? All right, you guys enjoy your day.